Hi everyone, a very good morning to all of you and welcome to the live virtual revisionary classes of Board of Studies ICAI. And we are discussing the corporate and other laws paper, and the topic which we will be discussing today in the revision is General Clauses Act and interpretation of the statutes. This is part of the CA intermediate course and the students who are appearing for examination in September 2026. Uh, you have already undergone this sessions, four sessions, two on General Clauses Act and two on interpretation of statutes. So today we will be going into the revision of it and will revisit certain important concepts, as well as the objective of the session today would be to clarify your doubts and any questions you have. I am sure by now you have gone through the literature which has been provided to you, and you have understood them, and the learning objective of these sessions have been achieved. In case you have any confusion on any of the topics or any clarification you require, please feel free to ask those questions, because this revisionary classes are meant for that. So we will be a bit fast in moving ahead, but during the questions which I have curated, you can ask me any point which you think is important for your understanding or you have not got the clarity on that. This topic we have discussed very, very soon. So I think your memory would be very fresh, and it will be, we will be refreshing our ideas on General Clauses Act and interpretation of statutes. Moving further, if you see the General Clauses Act and interpretation of statutes, I would like to give you a comparison between these two portions of your syllabus. So while General Clauses Act is dealt with by way of a central legislation, that is the General Clauses Act 1897, there are specific provisions under the General Clauses Act which talks about interpretation or which talks about construction of statutes. So it provides for some general definition which applies to all central statutes, that is section 3 to 4A. And then you will find some general rules to construction, like how do you deal with the repeal of laws? How do you deal with numbers? How do you deal with time? How do you deal with distance? Or if there is a pro rata adjustment of certain things in a provision, how do you deal with that? How do you deal with powers and functionaries of different government departments? What happens when somebody leaves the office and in his absence, who takes charge? What is the power of that office? If something has been done by an ex-commissioner, whether the present commissioner is bound by the decisions of the ex-commissioner. These are the things which are talked about in powers and functionaries. And you will find that all the central legislation has got one or the other regulator, or you may say one or the other, government official who is manning the offices. So they need some clarity in their functioning. They need some continuity, and this General Clauses Act Powers and Functionaries chapter gives them that, scope and gives them that power. And then there are provisions where you have seen orders, rules, etc., and then miscellaneous provisions. So these are enacted provisions. These are there in the law itself. So wherever there is a confusion, you can go back to this law and look at it. Then the question comes in our mind is that what is interpretation of statutes then? So the interpretation of statutes are basically the rules, the regulation, the rules, the principles which have been laid down by the court of law. And in India, we follow the common law system. We follow the the British system of stare decisis. So stare decisis basically is that you follow the precedent, right? So in a precedent, you look at how the courts have been interpreting the provisions. And while you will see, while interpreting the law, you apply many rules and you apply many customs, or you can say a way of interpreting a provision. So this is by way of the case laws, by way of established principles, and this exactly is the job of interpretation. So in interpretation of statutes, we are seeing the basic rules. These rules may not be in a statute format or in a written format, but over the years, these rules have been interpreted by courts, and that is how they have formed the bouquet of rules. They have formed a important set of rules for interpretation, and that is also very important, which we see in interpretation of statutes. So both General Clauses Act and interpretation of statutes are complementary in nature. They are not at difference, and hence we study them together. So one, General Clauses Act, we specifically refer to sections, whereas in interpretation of statutes, there are no sections. We are basically guided by landmark cases. So we look forward and go back to the landmark case where court has interpreted a particular situation, a particular factual situation in a way, and we apply those principles in another case in a different factual situation. So this is what we do in interpretation. So this is a major difference between them and complementarity between these two concepts, that is General Clauses Act and interpretation of statutes. So I hope you got idea as to the relationship between these two topics. And that is the reason today we are doing this revision class of both these topics together, so that you don't get confused in between these topics. There may be some topics which are overlapping between the general principles and the interpretation, because because at both the places we are talking about construction of a statutes. We are trying to bring some sense out of the law. So this is what is the objective and background. So if you see the General Clauses Act, there are 30 odd sections in this law, and it begins with general definitions, and then you are having the applicability of those sections in different areas. And we have already seen that the General Clauses Act applies to the central legislation and not to the state legislation. In fact, for the state legislation, there are separate General Clauses Act which different states have formed. We have seen the example of West Bengal. We have seen the example of Karnataka. So different states are having their own General Clauses Act, which applies to their own state legislations. But you must also note that General Clauses Act, which is applicable to the central legislation, can also be referred to by the state legislation if there is a confusion, if there is something which is contrary. Now, in terms of general rules of construction, Section 5 talks about when the law comes into operation and enactments. 6 talks about effect of repeal. That is a very important section, and you will see that Section 6, 6A, 7, 8. These are all sections which are dealing with repeal and effect of repeal and what happens when there is a repeal of an enactment, whether the action taken in the repealed law continues, whether what happens to the decisions already taken in the previous law, does it continue? And that is what exactly your effect of repeal Section 6 tells about. It says that whenever a statute gets repealed, the actions which have been taken, the rights which has accrued, the liability which has been incurred in those legislations are continuing in the even after the repeal, because these are the actions which have been taken in a law, and then that cannot go back. It has to continue. So we have seen that. And then what happens when a repealed enactment gets revived? That is Section 7. And how do you deal with the repealed enactments? What is the construction of references? Like, say, for example, there is one legislation which refers to a repealed enactment, and we have seen this example in Companies Act, right? So one of the provisions in a law referred to Companies Act 1956. After Companies Act 2013 amendment, that particular law did not change. Still, there was Companies Act 1956. So Section 8 basically talks about that you will be referring to the new law instead of Companies Act 1956 by virtue of Section 8 of the General Clauses Act. So these are some of the examples. And then in the general rules of construction, we have seen about commencement and termination of time. When do you calculate that? Then it talks about computation of time. Then it talks about measurement of distances. How do you measure the distances on a single plane, on a horizontal plane? Then duty to take pro rata in enactments, and then gender and number has been talked about. And in the chapter of power and functionaries, we saw power conferred to be exercisable from time to time. So it is not necessary that for every action there has to be an order or a power specifically given. If a generic power is there with an authority, they can work on a day-to-day basis. Then similarly, there is a power to appoint, include powers to appoint ex officio, and then power to appoint to include power to suspend or dismiss, and then substitution of functionaries, and how the offices of the government bodies successors are appointed, and successors take over the charge of office and continue in that. And then office official chiefs and subordinates, what is the relationship, how it functions. That is what is talked about in powers and functionaries from section 14 to 19. And if you see the provisions as to the orders, rules, and etc., there we had discussed about how to the orders has to be constructed, and different orders under different enactments. So here we talked about the delegated legislation as to who can make rules, who can make regulations, how you interpret those rules and regulations. One basic principle which I taught you was that the rules and regulations cannot go beyond the parent act. So the parent act, so on the top of everything is constitution. Nothing can go beyond constitution. And any law which has been made in India or the pre-existing law, if before constitution even, will become void if it is in contrast to the constitution. So it is important that all laws are confirming, or all laws are in line with the constitutional provision, particularly fundamental rights. If they are not, then they will be contrary, or you can say ultra vires, or you can say unconstitutional, or contrary to the constitution. Similarly, if a law is passed, say for example Companies Act 2013, so any rule made under Companies Act 2013 cannot override the provisions of Companies Act. It has to be in line with the Companies Act. So if there is a conflict between a company law rule definition and a definition which is given in Companies Act, always the precedence will be given to Companies Act rules. So Companies Act definition. So this is how you have to see the provisions as to orders, rules, and these are the things which are made. So that is dealt with under section 20 to 24. And then there were some miscellaneous provisions like what do you do in case of recovery of fines? How do you deal with the fine mechanism? And if there is a recovery of fine in case of civil fines, how do you deal with that? And then what is the service by post? How do you effectuate the service? And with there we discussed about the latest mechanism of service in an electronic means, and when service is complete, like if a registered post is done, then after the post is complete, the service is considered to be complete, and what is the relevance of this service. So we talked about that. And then application of Act 2 ordinances and several saving clauses in previous enactments and bylaws. So this is the overview of the General Clauses Act, which we covered. And in terms of the questions or in terms of the previous year questions, if you will see, you find questions from the definition section. So you may get a short note in defining certain concepts, and that we will see in a while. And then there are section 6, that is repeal, effect of repeal. The questions you have found that there are questions on repeal. You would find questions on construction of references to repeal, that is section 8. We have seen in the previous years, the questions have come on section 9 and 10. In certain situations, we have seen questions coming in section 12, 13 as well. And in terms of power and functionaries, we have seen questions, not plenty of questions around this, but maybe on section 14 or 15, you have a couple of questions which you have seen previously. In section 20 to 24, there are questions which comes under the rules and regulations, but not many questions I have seen from this particular part. And then if section 27 is important, where there were questions which has come around that particular area, because these are the sections wherein questions can be framed in a proper way. So you are supposed to look at them and answer it. So in my previous sessions, you have always asked a question that whether we need to remember the sections. Now here I would like to say that remembering the sections, there cannot be a straight answer, but definitely if you are quoting a good section, then it is enhancing the quality of your answers. Try to understand that this is a competitive examination. There are lakhs of students who appear for examinations, and the examiner is looking for some unique, answers. And in the set format also, I was looking at the examiner's comments in the previous year's sections, and particularly for General Clauses Act, their view is that the students have given quite generic answers and have not been specific towards the provision. So it is important, if there is a law and you have been taught that particular provision, so you should be more specific. And if you are able to reproduce the section or refer to the section, that will give you an additional weightage or mileage. If you forget it, I don't think that there will be minus marking or something, but definitely if there is the examiner compares one sheet from another sheet and he finds that in many of these sheets there are references to the sections, probably they will be swayed by that fact that you are supposed to remember sections. So depends on the cohort as to how you are dealing with the questions in General Clauses Act. Let me, move further and talk about the learning outcomes of the interpretations chapter. And if you see the interpretation of statutes, in the interpretation of statutes, you will find that primarily we are talking about the rules and the aids. So when we say rules, these are rules of interpretation. These are primary rules and secondary rules. And there are aids, or you can say help, for construction or interpretation. So there are two kinds of aids. One is called internal aids and the other one is external aid. Whenever we are referring to the statute and within the statute we are making references, this is referred to as internal aids. And whenever we seek help beyond the statute or outside the statute, we are talking about a situation of external aids. So we have discussed about internal aids, many internal aids and many external aids. So we will revise that today. And I'm sure you have gone through the provisions and you have, read the commentary on the interpretation of statutes in your course material. And if you have still any questions anywhere, please raise your hand and ask the questions. I will be more than happy to answer that, because the objective of today's session is not one-way lecture, but it is interaction. And it will be better if we interact and have questions and answers rather than taking another lecture on General Clauses Act and interpretation of statutes. So this is the background of what we have been discussing. But for both the General Clauses Act and interpretation of statutes, one thing is clear, that you have to, go through the provisions, deal with the case laws, situations, and remember them for answering the questions. In terms of interpretation, if you have a look at it, there are classification of interpretation. So there is a general classification of interpretation where we divide interpretation into legal and doctrinal interpretation. Okay. So whenever we say legal interpretation, it is we are concentrating on the text of the law or black letter law, we can say. And there, when we are, looking at the legislators, what they would have thought in their mind, we are talking about authentic interpretation. Or when we go into the rule of interpretation derived from some other sources like customs or case laws, then it is a usual interpretation. And in terms of doctrinal interpretation, there are two ways. One is called grammatical and the other one is logical. Whenever we say that the grammatical rules apply, if we are talking about ordinary rules of speech. So we are referring to the text, or we can consider this as literal rule of interpretation also. So whatever is written in the law, we just refer to that rule and make the interpretation. Whereas the logical interpretation is a situation where the court goes beyond the words and it tries to discover the intention of the statute in some other way. So this is the focus of the logical interpretation. And in uh, interpretation of statutes, the flow goes like this, that first you have to see the grammatical meaning, or you can say the literal rule of interpretation, and then subsequently you have to if you are not able to get hold of the meaning by way of the grammatical understanding, then you basically try to find out the logic, or you try to find out the broader sense of the provision and try to make sense of out of it. In fact, Fitzgerald, makes this distinction from 4 to 2, and he says one is the literal interpretation and the other one is the functional interpretation. So literal interpretation basically means that you are going by the written words in the law and try to make, meaning out of it. You don't have to supply anything, or you don't have to be logical there. And then other one is a functional interpretation where you are trying to find out the meaning out of the law by way of logic, and trying to deduce the interpretation from the provisions of the law. So these are the classification. This is there in your this book. And this actually, I have not seen any question which has come on this, except that what do you mean by literal rule of construction, or explain the logical, logical interpretation. So these kinds of questions have come, but there's no long question which has come that yes, classify the interpretation, because this is theoretical in nature. And I've seen that in your question papers, mostly the practical questions comes. So let us see. This is one of the questions in interpretation which has come up before. And this question says, what are the differences between interpretation and construction in the legal context? And how do these two concepts relate to each other as per interpretation of a statute? So this is a 4-marker question which has come in one of the previous examinations. So what do you think is your answer? If you have to answer this question, what would be your answer? You can use the chat box, or you can even use your mic. Raise your hand. The IT team will enable you to speak, and then you can speak. Go ahead. I hope you people are there. Okay. Right, Mary. Interpretation as it is, we take the meaning of the words. But this much, if you write, you will not get 4 marks. You have to have more articulate, write some more words into it, right? Any more responses? Okay. So if we have to answer this particular question, like we have to write at least this much. So if you see the answer, it will give you a clarity as to what is expected. So the two terms, interpretation and constructions, are used interchangeably. In India, we use it interchangeably to denote the process adopted by the courts to ascertain the meaning of the legislature from the words with which it is expressed. These two terms have different connotations. Interpretation is the art of ascertaining the meaning of words and true sense in which the author intended that they should be understood. Whereas if you talk about construction, it is about taking out meaning from the letter of law. And idea is to find the spirit of the legislation, to find the what exactly the legislation meant to achieve. So you can say that interpretation is basically the literal part, whereas construction is a logical part. Or you can say interpretation is the literal meaning, whereas construction is the logical, or you can say interpretation is grammatical and construction is logical, or interpretation is literal and construction is functional. So this is how you can define or distinguish between the concept of interpretation and construction. If you see the General Clauses Act uses the term construction, not interpretation. So it is trying to say that what do you construe, or what do you take out a meaning from the legislation, that is referred to as construction. Though in India, we interchangeably use both these terms, interpretation and construction. Well, this brings me to the four basic principles of interpretation, and this we have seen in our previous session. So, if you will see the four basic principles of interpretation are intention of the legislature. This is one important one where you first thing is that whenever you are onto interpretation, you want to interpret something, you want to make a meaning out of a legislation, you go back to the people who made this legislation. This is called intention of the legislature. And how do you find the intention of the legislature? Yes. Where do you find the intention of the legislature? Or what do you mean by intention of the legislature? Use the chat box. Intention of the legislature. Where do you find and what do you mean by intention of legislature? Yes. Yeah, any answers? Intention of the legislature. Yeah, what do you think, Gayatri? Intention of the legislature? Any one line to explain it? Manas, Vijay, Onkar. Where do you find the intention of the legislature? Okay, let me ask a question. Whether you find the intention of the legislature in internal aid or external aid. I hope I am audible to you people. Are you able to hear me? Okay, Gayatri, you say internal aid. That's correct. But do we find intention of the legislature in external aid? Can we find in external aid? And if yes, where? Your answer is correct, internal aid. But there are situations in which you find the intention of the legislature by external aid also. But where do you find this external aid to go ahead and find the intention of the legislature? Yeah, past laws. Okay, Gayatri. Past laws. Past laws intention of the legislature maybe intention of the legislature not, but in a mischief rule you utilize past laws. What was the law in the past? What is the law in the present? But if I have to say external aid, then I can say maybe the committee reports or the parliament debates or constituent assembly debates. These are the external aids which can be utilized to find out the intention of the legislature. I can give you example. When the courts had to interpret the insolvency and bankruptcy code, they referred to the debates around this area, particularly TK Vishwanathan committee report they have referred to in the court decisions initially to understand the intention of the legislature, right? Similarly, I have seen court referring to SVS Raghavan committee report in CCI versus SAIL case, where they were trying to understand the intention of the legislature behind the Competition Act. So, like that. So, the courts may see the intention of the legislature within the statute and outside the statute also. For within the statute, they look at the intention of the legislature through the preamble, through the short title, throughout the provisions, and see they and try to understand what legislature would have thought in making this law, right? So this is the primary thing. So whenever interpretation will happen, this is one of the basic principles or rules of interpretation, that whenever an interpretation has to be done, you look at the intention of the legislature. First thing is that. Second principle, which is an important principle equally, it says that statute must be read as a whole in its context. So we have already seen that context is the king, right? So whenever a statute or a law needs to be interpreted or has to be read, you cannot dissociate a legal provision and make a different meaning out of it than it wants to, submit. So statute has to be always read as a whole. Together, you have to read them. This is one of the important principles. The statute must be read as a whole in its context. Then third principle is about meaning, plain meaning. So you don't try to see additional meaning in a statute's provision. First thing first, which you do is you see the prima facie meaning, the simple meaning of the provision. And if it is not making sense, then you move on to the further construction or try to harmoniously interpreted, or these things you apply if the meaning is not plain. Uh, this principle says that irrespective of the consequences, many a times you will find that consequence of a provision is very harsh. But just because consequence of the provision is harsh, you don't, stop from giving effect to those provisions. As for example, you would have seen in one of the cases, and this I referred during my class also, that accused of murder, after 33 years, the person has been put behind bars for 2 years. And at present, the person is about 88 years old. But this a consequence to the person does not deter the law to put him behind bars, because that is the law was that for the punishment you have to go behind bars. So irrespective of the consequences, you have given plain meaning to the provision. This is the third principle. And the fourth important principle in interpretation is that you cannot just throw away the law saying that it is not interpretable, और इसका कोई मतलब नहीं बन रहा है, इसको हटा दीजिए. ऐसा नहीं कर सकते हैं. You need to read the law or the statute to make it effective and workable. So whenever a legislature has passed a law and there is an ambiguity, there is a challenge in implementing it, that itself does not mean that the law will be discarded. You need to make some sense out of that particular law, because if law has been passed by the legislature, it has got some meaning, it has got some objective, and you need to find out that objective, find out that meaning, and make the law applicable. This is the task and job of the courts. So if you will see, these four principles are very handy tools or handy guide in the hands of the court. And when they are faced with a situation, they are faced with a matter, they apply these principles to interpret the provisions or make construction out of the provisions. I hope this makes sense to you. Now let us move further and talk about object, purpose, and importance of General Clauses Act. So what do you think? What is the object and purpose and importance of General Clauses Act? If you can put it in your chat box. There are few objectives which I have already discussed now. If you see in a couple of slides back, I told you all those objects. If you can put it in one by one in the chat box. Object, purpose, and importance of General Clauses Act. Please type. That's a good answer, Gayatri. Shorten the language and uniformity across the legislation. Very good. So, one of the objectives of the General Clauses Act is to shorten the language, and you don't have to repeat whatever is there in General Clauses Act again and again in all the central legislation. There will be more than 1,000 legislation, central legislation. If General Clauses Act would not have been there, all these provisions you have to repeat again and again. Okay. So that is reduced, and definitely it brings uniformity, because otherwise if you have definition in one section, you may miss something in another section, and that thing is avoided by way of General Clauses Act. Very good. Any other point? So you have seen me answering. I have used several examples, several points. So you can lengthen them. When you write, shorten the language and uniformity, you can provide some example also. Just I mentioned just like that. Okay. What more other than this? Anybody else other than Gayatri who is active or present? Okay. shorten the language of central acts, uniformity. This has been covered. So, to state explicitly certain convenient rules for construction and interpretation. So, rules of construction is also provided for certain situations. This is what is one of the important tasks of General Clauses Act as well. And then we have to guard against slips and oversights by importing into every act certain common clauses and inserted in every central act, right? This is what exactly has been held by Supreme Court in Chief Inspector of Mines versus Lala Karamchand. And there the court has said that the purpose of the act is to avoid superfluity of language in statutes wherever it is possible to do so. So whatever General Clauses Act says, whether as regards to the meaning of words or as regards legal principles, has to be read in every statute to which it applies, right? So this is the objective of and importance of General Clauses Act. Now, in my previous class, I had told you about Constitution Article 13. And why do you think Article 13 is important, Constitution of India? Why we are referring it here? See, since you people are not asking questions, I am asking you questions because it is a revisionary class. We need to interact. So you have to give some inputs and take some inputs. That is the objective of this class. It is not a one-way class. Yes. So tell me, what is Constitution's Article 13? What is the relevance of this? Why we are talking about this here in these two topics? Yeah. Go ahead. I'm waiting for your answer. Article 13 of the Constitution, basically that defines laws, right? So if you see Article 13, it says all laws in force in territory of India has to be in conformity with the fundamental rights of the Constitution. So no law can breach the fundamental right provisions under the Constitution of India. And if anyone makes any law or any state makes any law which is contrary to the fundamental rights, that will be void as per the Constitution. And the most important thing is that there is the definition of law given in Article 13 sub clause 3. So as per that definition, the law is a broader concept, right? So it is not only the act of the parliament, but it also includes ordinances, it includes orders, it includes bylaws, rules, regulations, notifications, customs, or usage, even within the territory of India. And there is also a concept of laws in force. So, what is laws in force? Is there a difference between law and laws in force? And can you give an example of this law and laws in force? Any example? Yes. Any example of law and laws in force? I hope I am connected and you are able to hear me, all of you. Can you people confirm if I am audible? Okay, Gayatri. Law is which is enforced. Law enforced means which has implemented by that certain department. Okay. Gayatri, I think this is not exactly the answer. Law and laws in force. Uh, laws in force and laws. Uh, so when we say law, law is something which is passed by the parliament. That is called law. So every law is actually a law, but they may not be law in force. So law in force is a situation where law is notified to be implemented. So there may be law which are there in the statute book, but yet to be implemented. And we have seen the example under the DPDP rules, that is, data protection and privacy rules. So if you will see, DPDP rules are yet to be notified fully, right? In May 2027, everything will become notified. So when it will come into force? In May. So the any of the law, the parliament may or the government may decide the notification date. And whenever that notification comes, then only you can say laws are in force now. So this is the concept of laws in force. I hope you understood this point. Let me take you to the different parts of the legislation, and this we had discussed. So in a legislation, you have date of the publication in the Gazette. This is an important date. You also have date when President gave assent to the legislation and title of the law. So this is the important date because this is the date on which the law comes on paper and in statute. However, you may note that this is not the date when law comes into force. Law may come into force on different dates also. So President may have given assent on 11th August 2023, but the law may prescribe that it will come into effect on such and such date. Or maybe, say, for example, it is saying 1st November 2023 or maybe 2025. So that can be written in the law itself. So laws will come on force on that particular date. Let us talk about something more important things in the statute. So there is always a preamble you will find in the beginning. So preamble is basically the background, or you can say the scope of the legislation, and preamble explains why the law is there. So you can see here, this law is relating to data protection, and it says an act to provide for processing of digital personal data in a manner that recognizes both the right of the individual to protect their personal data and need to process such personal data for lawful purposes and for matters connected therewith. So this is the preamble. Then you have short title. Short title of the law here is the Digital Personal Data Protection Act, DPDP Act 2023. Likewise, in all law, section 1 will talk about short title. Then there is commencement and extent of application. So I was just telling you, right? So the different laws can be enforced on different dates. And that is what exactly one subclause 2 says. So you can read here. It says it shall come into force on such date as central government may by notification of the act, and any reference in such provisions shall be construed. So central government may notify different dates for interpretation of application of that particular law. Then in any of the legislation, you will find definition clause. So you can see there are all definitions which are defined. So if you see, for example, child is defined, right? So it says child means an individual who has not completed the age of 18 years. Now, this definition of child may be different in Juvenile Justice Act, or maybe for that matter, IPC or Bharatiya Nyaya Sanhita. So the definition of child here is applicable in case of DPDP Act only, and you have to refer to wherever the word child comes in this legislation, you will go back to the definition clause. If you don't find the meaning here, or there is a confusion, you can go back to the General Process Act also. And then if not, then go to the different court interpretation. Similarly, there is a data which is defined here. So this definition of data may vary than in Information Technology Act or maybe any other legislation where data is defined. So data is not defined in General Clauses Act, by the way. So this is how you see the definition clause, a very important clause in a legislation to find out meaning on what exactly the words, different words used in the legislation mean. And since these all points are inside a statute or inside a legislation, these are referred to as internal aid to construction. So these are all internal aids to construction because they are part of the statute itself. Inside a statute, you will find preamble, short title, commencement, definition clause, and hence they are all called internal aid to construction. So, this I have already told you. This is an example of Companies Act, wherein you can see it refers to the Securities Contract Regulation Act, SEBI Act, and Depositories Act. So what it is basically saying is that there is a principle with reference to this, which for SCRA, Depositories Act, and SEBI Act is what with reference to Companies Act? Can you tell me? There is a maxim. We have discussed this before. What do we call this? Companies Act is in dash to Securities Contract Regulation Act. Yeah, I'm waiting for the answer. This is a quite interesting quiz. What is that maxim called? I can give you a hint. It starts with P. That's not prospectus. Yeah, prospectus is a different topic. In interpretation, what is that? Yes. Daksh, I will explain you this beneficial construction, okay? But please answer me. My question is that here you are able to see these three legislation referred to in comparison to Companies Act. What is the relationship between them? And there is a word. Okay, this is a two-letter word. Two-letter word. One starts with P, another starts with M. Now I have given you sufficient hint. Now you should answer. Yeah. Okay. Any one of you is trying. So this is called pari-materia. Okay. Pari-materia. So we can say that SCRA, Depositories Act, and SEBI Act are in pari-materia to Companies Act, or Companies Act is in pari-materia to Securities Exchange Board of India Act, SCRA, and Depositories Act. Okay. So whenever the statutes are in pari-materia, you can refer to their definitions inter se, or you can take help of interpretation from one statute to another statute, right? They should be related statutes. So you cannot say that CPC and CRPC are in pari materia because their principles and philosophy is different. Okay. I hope this made sense to you. Now let me move further and talk about delegated legislation. So in a statute, there will be also delegated legislations. So delegated legislation basically is the power of making rules and regulations. So the statute gives power to the central government to make regulations at most of rules, sorry, and regulations to the regulators. So in most of the statutes, you will find that there are rule-making powers given to the central government. And as per the allocation of business rules, the central government functions are bifurcated among different ministries. So it depends that what kind of a legislation it is. Different ministries will get power to make rules. Like for example, with reference to Competition Act, it is Ministry of Corporate Affairs. With reference to Insolvency Bankruptcy Code, it is again Ministry of Corporate Affairs. With reference to SEBI, it is Ministry of Finance, which gets the power. Similarly, if I am talking about startups, so DPIIT, Department of Public and Internal Trade, is the body which gets the power to make rules, right? Similarly, regulations can be made by the different regulators, like Insolvency Bankruptcy Board of India gets the power to make regulations for insolvency professionals. Likewise, there are regulations which can be framed for the chartered accountants under the National Financial Reporting Authority framework. So these are different delegated legislations. Now, tell me the answer of this particular question. This is a question for you. Read it and provide some answer. Yeah. Read the question. It says Mr. Sohan has issued a promissory note of 1,000 to Mr. Mohan on 17th May, payable 3 months after date. After that, sudden holiday was declared on 20th August due to Muharram. As per the provisions of General Clauses Act, what should be the date of presentment of promissory note for payment? Whether it should be 19th August or 21st August. You have to answer that, as well as you have to tell me the section, which section applies here of the General Clauses Act. Yes. Good, Daksh. You have given the answer, but which section? Section 10. Gayatri says Section 10 of the General Clauses Act. And Gayatri, you are right. Section 10 of the General Clauses Act provides whereby any legislation or regulation, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day or within a prescribed period, then if the court or office is closed on that day or last day of the prescribed period, the act or proceeding shall be construed as done or taken in due time if it is done or taken on the next day afterwards on the court or office is open. This is very practical provision, right? So in this particular case, since it is falling a public holiday, then on the next working day, that is 21st August 2021, would be the date on which the payment or payment on the promissory note can be made. Well, now let us move further and talk about this question. This question we have seen many times, so you should be able to answer it fast. Okay. It is Daksh, your answer is quite smart. You are using both. It is directed to be mandatory. Okay. So whether it is directory or mandatory, your May is mandatory. Yes, you are right. May is mandatory. Why May is mandatory? Because you cannot, form a company for any unlawful purpose. It has to be by way of lawful purpose, and here May is read as mandatory. Otherwise, the nature of may and shall is mandatory, may is directory, but in certain situations may be read as shall. This we have discussed, and this answer here is may is mandatory. Okay, let us look at another question. Yes. What do you say? Go ahead. Gayatri, what would be the answer to this? It is with repeal, but what? Which section of the General Clauses Act? And what would be the answer? Daksh, your answer is opposite actually. So if you see, here the provisions of Companies Act will apply to the Income Tax Act. Because what is the change? Change is between the Companies Act, right? So Income Tax Act refers to Companies Act 1956 and Companies Act 2013 got changed. But the Income Tax Act has not yet changed in the 1956. So as per General Clauses Act, the changed provision will apply to the Income Tax Act. Right? I hope you got this. This is what exactly is talked about, Section 8 of the General Clauses Act. And we also have a case law towards this, that is Gauri Shankar Gaur versus State of UP. Take a second to read this. So if this is the question, then you are expected to write this much. Okay. You have to be a bit, you know, articulate. You need to write the answer. And I told you before, prepare your notes on each of these sections so that it becomes easier for you. Say, for example, you are able to locate that this section 8 is applicable here, then you should write few lines into your answer. Okay. Right. Let me take you to another question. Yes, if you write in this format, it is good because it will give you a leverage. Right. See the question and then move ahead. So, Gayatri, your point with reference to the previous question, or old law given, old law has been enacted by new law. Old law is not has been enacted by new law. Old has been replaced by the new law, right? So, all the references to the old law in any of the statute will convert to the reference to the new law. This is what will happen. Okay. Daksh, can you explain your answer? Why sale of tamarind is not the sale of immovable property? Yeah. And when it will become a sale of immovable property? If it has to become a sale of immovable property, when it will become? Okay. Anything permanently attached to land is immovable property. Tamarind is for the purpose of consumption. So, no, no, no. It is not talking about tamarind for the tamarind. If it is attached to the tree, then it will be immovable property itself. But since these timbers are cut from the land and kept separately, that is why it is called movable property. So this 326 defines the immovable property, and it has talked about, and this question has come many times. So it is land, benefits arising out of the land, things attached to the earth. You would recollect one of the fish example I gave you. So fishing rights, right to fish in a pond, is basically a immovable property. Why? Because this is the benefit arising out of the land. Okay. So it is an inclusive definition. It contains four elements, as you can see here. And in this case, it is, land, timber is separated from the land, and hence it is a movable property and not a immovable property. Okay. What is the answer? Which provision applies? Yes, to all of you. Yes, awaiting your answer. Which provision applies? And what would be the answer? Yes, good answer, Daksh. So in this case, her plea or her argument that you know it applies only to male, not females, is not correct, because the provision relating to gender, and the if you see the provision relating to gender, It is defined, it is given in section 13 of the General Clauses Act, right? So it specifically says that all central acts or regulations, unless there is anything repugnant in the subject or context, words importing the masculine gender shall be taken into include females. And we have also seen nowadays it includes transgender. So Mrs. Neelu Chandra, director of Laddu Sweets Limited, has made an undue gain in the form of commission. So she will be denied accepting the liability, but she cannot do that, right? As per the General Clauses Act. Okay, let us talk about this. It's quite easy because you have just answered the question, and you are one of you. Respond. Now you should tell me the section also because we have just discussed this. Yes, Gayatri, it is section 326. What is the answer? Whether the sale of trees will be considered as immovable property? Yes. Good. So this is the answer. It will be considered as immovable property. Good. Now let us move further, talk about this, and tell me what is the section also. I've got only one answer. Gayatri says section 12. Is it right? What is the name of the provision? Section 12, Gayatri, what is the name of the section or explanatory note of this? Provide that as well, along with the problem solution. Good. So it is basically pro rata, right? It is section 12, duty to be taken pro rata in enactments, right? So what does the law says? Whereby any enactment now in force or hereafter to be in force, any duty of customs or excise or in the nature thereof is leviable on any given quantity by weight, measure, or value of any goods or merchandise, then a like duty is leviable. So in this case, you can see here, there was, 100 bottles and each is valued 50. So there is a shipment. So you have to take 15%. 15% of 100 bottles, each valued 50 is equal to 750. Right? Let us take another question. What do you think is your answer? Yes, come on, be fast. So what would be the date, Daksh, in this? Because there is a specific date given. Give me the answer. You have rightly decoded the provision applicable, but what is the date? Which provision of the General Clauses Act? And we have discussed the concept, Article 13, right? Laws in force. So you can also. Mhm. 313, it is section 5 of the General Clauses Act, Gayatri. And it says where any central act has not specifically mentioned a particular date to come into force, it shall be implemented on the day on which it receives the assent of the Governor General in case of general acts prior to the this, or in case of precedent, in case of act of parliament after independence. And in a given question, you can see here, it is the 1st September 2024, which will be the date when it will come into force. I hope it is making sense to you. Right? Okay, so I think it is a break time. Let us take a break, short break, maybe not more than 5 minutes, and we meet at 8:25. Okay. 327, Gayatri says 327, that is imprisonment. Okay, but what is your explanation to this answer? If you have to explain a bit, because you cannot just write 327 imprisonment for answer to this. So you have to elaborate it. How do you do that? You can use your mic also if you want to speak. Yeah. Go ahead. So it is 327 of the General Clauses Act, which states imprisonment shall mean imprisonment of either description as defined in Indian Penal Code. Now this Indian Penal Code is replaced with Bharatiya Nyaya Samhita. By Section 53 of the Indian Penal Code, the punishment to which offenders are liable under that code are imprisonment, which is of two descriptions, namely rigorous imprisonment, that is with hard labor and simple. So when an act provides that an offense is punishable with imprisonment, the court may, in its discretion, make the imprisonment rigorous or simple. In this case, the court considers Mr. N's offense as a minor theft and believes it does not warrant harsh punishment. It might sentence him to simple imprisonment. However, if the theft involved force, was committed in a violent manner, or if Mr. N has a history of criminal behavior, the court may decide to impose rigorous imprisonment. I hope this is something which you relate to. Now, this is the question. I think this we have already discussed. Can you explain now again? We have just discussed, while ago. Try to articulate the answer in a good way because we have just discussed about applicability of the repealed enactment referred to in another legislation. This is the provision. Yeah. What is your answer? Go ahead. Looking forward to your answer. The people who have not answered so far can attempt this. Okay, it appears that you all are engrossed with something. Just see. It is Section 8 of the General Clauses Act. So, this act or central act regulation made after the commencement of this act repeals and reenacts with or without modification any provision of a former enactment, then references in any other enactment or in any instrument to the provisions so repealed shall, unless a different contention appears, be construed as references to the provisions so enacted. So, and there is also a case law to this effect, that is Gauri Shankar Gaur versus State of UP, that every act has its own distinction. If a later act merely makes a reference to a former act or existing law, it is only by reference, and all amendments, repeals, new law subsequently made will have effect unless its operation is saved by the relevant provisions of the sections of the Act. The answer for this is the easier one. It has you have to only give the choice, but I would expect if you can provide some detail also. Go ahead. Okay, so I have got the responses, and we say C. Gayatri says C, and C is the right answer. And definitely this relates to the provision of double jeopardy, right? Article 20, Clause 2 of the Constitution of India. Because they cannot be prosecuted for same offense under two legislations, right? Okay. What do you have an answer to this? How will you interpret the definition in a statute if the following words are used in a statute? Means and includes. Give one example of each means and includes. So if in a definition clause, there is a term used means and there is a term used includes. So what do you mean by that? What is the interpretation? And if you can supplement it with some example. Go ahead. Means and includes. Supplementing it with example. Okay, let me see, some response has come. Okay, Gayatri, you have said director means debenture includes. Can you explain it? What does it mean? Okay. Daksh says means is an exhaustive word, whereas the includes is an inclusive word. Okay. Can you give an example? Any example of this? Okay. So you can, okay, Gayatri, that's a good answer, Gayatri. Debenture includes stocks, bonds, etc. Good. And when you talk about the director, there's that. Okay, fine. So interpretation of the words means and includes in the definition. So definition of a word or expression in the definition section may either be restricting of its ordinary meaning or may be extensive of the same. So when a word is defined to mean such and such, the definition is prima facie restrictive and exhaustive. We must restrict the meaning of the word to that given in the definition section. But where the word is defined to include such and such, the definition is prima facie extensive. Here, the word definition is not restricted to the meaning assigned to it, but has extensive meaning, which also includes the meaning assigned to it in the definition section. So, example of this would be definition of director. Section 2, subclause 34 of the Companies Act. Director means director appointed to the board of the company. Whereas definition for whole-time director, if you see it, it says includes. So it may include some more categories of directors also in its definition. Right. Let me see. There is one more response. Okay, Nitu, that's a good response. Means so and so. Private company means a company other than a public company. Okay, fine. Now let me move further. What is the answer for this? This is under the General Clauses Act. So please provide your answer. Yeah. This is referring to Section 26 of the General Clauses Act and Article 22 of the Constitution of India. Which provision it is talking about? There is a term utilized for this. I have discussed this before with you. What is that term? Okay, Gayatri, noted your answer. You are saying B, but what is the term utilized? Yeah. Is it double geopardy? Okay, right. So it is double geopardy. Right, good. So what is your answer? Let us see. Answer is B, not valid because the specifics, actions, and legal provisions violated are different in this situation. So there can be different actions which can be taken in this. Okay, let us talk about this. This question relates to non-obstante clause. So remember non-obstante clause, there are four categories of non-obstante, which we discussed in our classes. So with reference to that, that is the hint for answering this. So think about it and answer. So you can see here that a clause that begins with notwithstanding anything contained is called a non-obstante clause. So generally in a subject to clause, the notwithstanding clause has a effect of making the provision prevail over others, right? So whenever there is a term used, then the clause will prevail over other provisions. So we discussed these four stages of non-obstante clause, four levels of non-obstante clause in the statute. The first level talks about the notwithstanding anything contained in another section or subsection of that statute. So when we are referring to section 4211, 4211 is saying it is referring only to the subsection or section, right? It's not going beyond that. Second level is where it is non-obstante the whole law, the act, right? So this is section 8.8 of the Companies Act. It is saying that anything contained in the Companies Act. Then there can be non-obstante with reference to the other enactment also. Like section 7A of the Securities Contract Regulation Act says anything which has been mentioned in Securities Contract Regulation Act as well as Companies Act. So whatever is mentioned here will prevail over both these things. And then there is a notwithstanding with all other laws. So there may be provision which says that notwithstanding anything contained in any other law for the time being in force, whatever is mentioned in that law will prevail. Now, the fourth category, if you will see in many of the legislation, there is a conflict with reference to fourth category. Because all kinds of legislation nowadays which is coming is using this word, notwithstanding anything contained in any other law for the timing in force. So the rule of interpretation here comes is whichever is the latest law will prevail over the older laws. Now that creates sometimes a confusion. And then there is also one principle which you would be remembering is that the special law prevails over the general law. That is also there. So courts in such situations have always come up with a harmonious construction. So they have tried to build up harmony between two sections and two provisions and see to it that both of them can sustain and both of them can proceed. This is how they have dealt with the provisions of notwithstanding. If you read a bit more, you will be able to understand this very, very clearly. But try to understand that the first level is within the section. Second level is within the law. Third level is with reference to another law. Fourth level is with reference to all the laws. This is how you have to, remember them. Well, let us talk about this question. This is what is the meaning of legal significance of the principle generalia specialibus non derogant? With an example, can you make us understand this? Any one of you can attempt this. Go ahead, waiting your response. Generalia specialibus non derogant. Explain and give an example. Yes. Any response? Okay, so just now I explained you about this special law prevails over the general law. So this maxim talks about that, right? So the principle generalia specialibus non derogant means that when a general law or a specific law addresses the same subject matter, the specific law prevails. Okay. So this ensures that specialized laws designed for particular situations are not overridden by broader, more general provisions. What could be the example? Let us see. All contracts must be in writing to be legally enforceable. This is the general law. But special law says an oral contract for sale of goods under 5,000 is legally valid. So this is a exception to what the general law says. All contract has to be in writing. But special law, that is sale of goods, says that if the transaction is below rupees 5,000, then it may be legally valid. So here the rule states that all contracts must be in writing. However, the specific rule creates an exception for oral contracts involving goods under 5,000. According to the principle of generalia specialis non derogant, the specific rule will prevail in this particular case. Can you create a non-obstantive clause out of this? These two non-obstantive clause. Yeah. Yes. Can you create a non-obstantive clause out of this situation? So this will make me understand that you have understood non-obstantive. Yeah. You will name it like this, notwithstanding the general law on contract. Now, what is the general law on contract? That contract should be in writing, right? So we are creating a non-obstantive clause. We are saying notwithstanding the general law of contract, an oral contract for sale of goods under rupees 5,000 is legally valid. So what are we creating? We are creating an exception in the general law by way of sales of goods under 5,000 rupees. So this is how non-obstantive clause will work. Okay. What is meant by beneficial construction? Right. Here comes. I think Daksh, this was your question. What is meant by beneficial construction in statutory interpretation? Under what circumstances the rule of beneficial construction is generally applied? Now let me answer this. So beneficial construction is not a strict rule of interpretation, but rather a method used to interpret a statute liberally in order to give effect to declared intention of the legislature, particularly when the statute is enacted to benefit a specific class of people. Like, for example, labor laws that are meant to benefit the labor, and hence most of the times it will be interpreted as supporting the labor. Similarly, tenancy laws in support of tenants. Similarly, if you see the laws relating to maternity benefit or women, all these particular things are basically beneficial legislation. So beneficial construction will be applied to these statutes, and they would like to help the certain class of people and who are underprivileged or who have not been treated fairly in the past. So in such cases, it is permissible to give an extended meaning to the words or clauses, but this can only be done when two constructions are reasonably possible. So if you cannot extend the benefit out of the way, but if there are two constructions possible, one is giving more benefit, you can go ahead with that construction. This is the rule of beneficial construction. I hope it is clear to you, Daksh. Let us talk about this question. This we have already dealt with, so we will skip this. This is section 8 of the General Clauses Act. And case law is Gauri Shankar versus State of UP. Let us talk about this. What is this? Associate words to be understood in common sense manner. Explain the statement. Which maxim we are discussing about? Which maxim we are discussing here? Yes. Tell me which maxim we are discussing here. Nitu, very good. So it is nocitur res socii. And can you give an example of this? Well, so we are discussing about nocitur res socii. And when two words or expressions are coupled together, one of which generally excludes the other, obviously the more general term is used in a meaning, right? So when two or more words which are capable of analogous or same meaning are coupled together, they are to be understood in their cognate sense, that is, same sense. They take as it were their color from each other. The more general word is restricted to a sense of analogous, right? We have, could you remember the example which we discussed in this particular maxim during the session? We discussed the example of perfumery. We discussed the example of orange juice and packaged drinking water, packaged juice. Okay. Now there is a principle of interpretation. It is saying what does the principle of reading the statute as a whole imply in the interpretation of statutes? Explain. What do you think would be your answer? Yes. What do you think would be your answer? Well, literal primary rule need to is applies in all situation, but here we are specifically talking about a principle, right? So there were four principles which we discussed. And one of the principles says that you have to read the statute as a whole. You cannot pick up one part of it. What do you mean by that? That is the question. So if you have to answer, you have to say it is elementary principle that construction of a statute has to be made of all its parts taken together and not of one part only. The deed must be read as a whole in order to ascertain the true meaning and of its several clauses. You cannot just pick up one clause and interpret in your favor and leave the remaining one. Because in a law, there will be proviso, there will be many other things. All these things has to be together read and in unison. So one of the safest guides to the construction of sweeping general words is to examine words, examine other words of like import in the same enactment and try to find out the meaning of it. This is what is called reading everything together. So, for example, if one section of the act requires notice should be given, then a verbal notice would generally be sufficient. But if another section provides that the notice should be served on a person or left with him or in a particular manner or place, then it would obviously indicate that a written notice was indicated. So, you have to read those things together and then give the interpretation. Okay. What is the answer to this? What does the principle of reading the statute as a whole imply in interpretation of statutes? Explain with the help of an example. So I expect an example from you on this. Any example you can give other than the example which I gave you just. Go ahead. Any example you can give? Yes. What does the principle of reading the statute as a whole imply in interpretation of statutes? Explain with the example. So, a statute must be interpreted in its entirety, not in isolation. Words and sections derive meaning from context, ensure consistency and coherence in interpretation, avoid contradictions and redundancy, give effect to the legislative intent, and this has to be linked with harmonious construction. This prevents misleading or narrow interpretation. So, say for example, one section prohibits pollution, another allows discharge with permit. Now, these are the two different things. In one section, it is saying that don't pollute. In another section, it is saying that you take permit before you pollute. So you have to read them together. So there is a regulated provision and it is not an absolute prohibition. So you have to follow the regulations for getting the environmental clearances. Well, now let us take you forward. What is this? It says no person shall be prosecuted and punished for the same offense more than once. Explain in light of provisions of the General Clauses Act. What we are talking about? We have discussed this just now. Which provision it is dealing with? Which provision it is dealing with? Okay. Neetu says section 26. What else? Any one of you? So it is section 26. Very good, Neetu. Section 26. It says section 26 of the General Clauses Act. Wherever there is an act or omission, it constitutes an offense under two or more enactments, then the offender shall be liable to be prosecuted and punished under either or any of those enactments, but shall not be punished twice for the same offense. And we have seen this. Article 20, subclause 2 of the Constitution of India states this principle very clearly, also called action against double jeopardy. So, provision of Section 26 of the General Clauses Act, read with Article 22 of the Constitution, applies only when two the offences for which form the subject of the prosecution is the same, that is, the ingredient which constitute the two offences are the same. If the offenses under the two enactments are distinct and not identical, we have seen two examples also before that. So that is giving us the clarity. At the time of interpreting of a statute, what will be the effect of usage, custom or practice? What do you think would be the answer? Custom, usage and practice. Yes, this is a important tool for interpretation, usage or customs and practices. Where does it come? Which one? Literal or logical or grammatical or authentic? Which kind of a interpretation it is under the classification of interpretation? Usage or customs and practice? Right? So it relates to a very important maxim that is contemporanea expositio et optima et forticia illege, right? So it basically says that usage or practice developed under the statute is indicative of the meaning recognized to its words by contemporary opinion. A uniform, notorious practice continued under an old statute and inaction of the legislature to amend the same are important factors to show that the practice are followed was based on correct understanding of the law. I gave you example last time we discussed this of Sati Pratha and Triple Talaq. These are the two instant examples of curing an old usage or practice. So it is not necessary that old usage and practice will continue if it is illegal or it cannot be changed. That can be changed. But if you see the courts would generally not interfere with usage. So if there is something which is continuing or there is a usage, they will continue with that irrespective of the fact that there may be some minor hassles. So old statutes, while you are interpreting the old statutes, this aspect of custom and usage becomes very important. Okay. Now tell me, when can the preamble be used as an aid to interpretation of statutes? And first of all, whether it is a internal or an external aid to construction, and when it can be utilized. Give your answer. Okay, good Gayatri. Preamble is an internal aid to construction, but when it can be used? Yes. Okay. So you can see here, while the preamble can be used to know the aims and objects of the legislation, it cannot control or qualify the meaning of the statute. So whatever is expressly mentioned will continue, and the provision contained in the act has to be read along with the interpretation. And if you will see, we are talking about preamble of a statute and preamble of a constitution. These are two different things. Preamble of a statute will have a different meaning, and preamble of a constitution will have a different meaning. So preamble of a constitution is considered as the part of the constitution, whereas preamble of a statute is part of the statute, but both the interpretation vary. In constitution, preamble is considered as very important, whereas in case of statute, whenever there is a requirement, then only they are utilized. So if you see, there are two situations in which preamble can be utilized for interpretation. One, where there is any ambiguity in the words of an enactment, the assistance of the preamble may be taken to resolve the conflict. And situation two is a situation where the words of an enactment appear to be too general in scope or application, then courts may resort to the preamble to determine the scope. or limited application for which the words are meant, right? So this is the objective of preamble. Okay. Now let us look at the next question. Explain the meaning of without prejudice as a harmonious aid to interpretation of statutes. Give your explanation on this. What is without prejudice? Again, without prejudice is an exception rule. If you see, it is a exception rule. Can you explain without prejudice? Yeah. Awaiting your answer without prejudice. Okay. It appears you people are all waiting for your breakfast. Huh? No responses coming. So without prejudice, if you see without prejudice, when certain particular provisions follow general provisions, and when it is stated that the particular provisions are without prejudice to those general provisions, the particular provisions would not restrict or limit the operation and generality of the preceding general provision. So if, say, for example, Section 4, Subclause 3 of the Companies Act says, without prejudice to the provisions of subsection 2, a company shall not be registered with the name which contains so and so. Now here it implies that registering the name of a company, provisions of section 4.2 shall also be operative. So basically here when we say without prejudice to such and such thing, that means that you are creating an exception with reference to that thing. Like say, I say without prejudice to my rights to go to court, I am entering into this agreement. That means what? While I am entering into this agreement right now, but if my rights are violated, I can also go to the courts. So I am not excusing my right to go to courts, or I am not giving away my right to going courts. Right? So I hope this is clear to you without prejudice. This is a legal language many a times used in the statutes. Okay, this is a case study, and this we had discussed in our previous class. Can you tell me this study relates to what aspect of General Clauses Act and what concept is being discussed here? Yes. What concept and what aspect of General Clauses Act? Yes. Could you get it? Gayatri, that's right, relating to serving a post, but which section of the General Clauses Act? You are also right, Neetu. Notice by registered post, section 27. Okay, very good. So what would be the answer in this case? What would be the answer in this case? Yeah, let us note your answer. What is your answer in this case? Okay, so if you see here, here the provision relating to is 27, right? And if you see this particular case, what he has done, Rachit, he has not updated his address with the income tax department. So if income tax department has issued a notice, that particular notice will be held valid. That is properly addressing, prepaying, and posting by registered post. Further, on the basis of decision taken by the apex court in the case of Jagdish Singh versus Nathu Singh, where a notice is sent to the landlord by registered post and the same is returned by the tenant with an endorsement of refusal, it will be presumed that the notice has been served, right? So in this case, if you see the income tax department has properly addressed and registered the post, registered post was proper service of notice. It was the duty of the Mr. Rachit to update the address. So in this case, it will be considered as correct decision by the income tax department. Well, now let us move further and talk about this question. This question deals with financial year. So there was a confusion which arose among financial executives and accountant of a company. Both were having different arguments regarding meaning of financial year and calendar year. Which provision of the General Clauses Act deals with financial year and calendar year? Can you answer? Yes. 321. I think yes. 321 of the General Clauses Act talks about that financial year, and the term year has been defined in 366. Okay. So financial year starts from 1st of April, whereas calendar year in 1st of January. That's good. Now, what is the, if you have to explain following terms as an external aid of interpretation, can you throw some light on them? Historical setting and use of foreign decision. Give me one example each in both the cases. In which case historical setting has been used and in which case use of foreign decisions has been used. Yes. Go ahead. Okay. So let me explain you. So when we say historical setting, the history of the external circumstances. So many a times you go ahead with parliamentary history. You look at the ancient statutes. You look at the what has happened in the past. These are historical settings. Like for example, IBC interpretations. Most of the times, court will go into the historical setting. That why this law came up. What was the law before? Then you have seen foreign decisions. Many a times, foreign decisions are also referred to by the courts to make sense of the situation. Like, for example, we have seen in case of CEDAW, CEDAW was referred in Vishaka versus State of Rajasthan for implementing the POSH Act or POSH law, right? Likewise, there are different foreign decisions which has been referred to by the courts. Now, this is the question. Can you answer which provision of the General Clauses Act applies and what is the answer in this case? Yes, it is dealing with computation of time, Gayatri. Which section? Yes, it is talking about from and to, and you, exclude the day on which you are counting and you include the last day. That is what happens here, right? So this is section 9 of the General Clauses Act, which talks about computation of time. And the section says that in any legislation or regulation, it shall be sufficient for the purpose of excluding the first in a series of days or any other period of time to use the word from, and for the purpose of including the last in a series of days or any other period of time to use the word to. Now, in this particular case, the answer is 7th, 9th and 7th, 9th August and 7th September. Both days will be inclusive. So 30 days you have to count. So you leave the first day and count the last day. Well, now explain interpretation of a statute. Aid, read the statute as a whole. What do you mean by that? So read the statute as a whole is a elementary principle. So you have to read the whole statute together, and you have to not dissociate different provisions. You have to see the complete provisions together and then interpret it. This is what is the concept of read the statute as a whole, or this is the principle. Now, how do you utilize the heading and title of the chapter as internal aid to the interpretation of statutes? So if you look at any statute at a glance, you will find that generally the number of the sections are referred to in a particular subject or a group. So while these headings are important, but they don't control the meaning of the sections. So generally, headings would be, supportive in interpretation, but they don't control the interpretation of the section. Now, there in General Clauses Act, you may have a short note on movable property and oath. So we have already discussed the definition of immovable property, 336. So with reference to 336, you have to read movable property and explain that accordingly. So there are 4 points in 336. That is land, benefit arising out of the land. And what are the other two? Things attached to them or machinery or attached to the land. And in oath, the section 337 defines oath, and it includes the affirmation and declaration in case of persons by law allowed to affirm or declare instead of swearing. We also saw the difference between swearing and affirmation. Swearing is with reference to religious, and affirmation and declaration is not requiring any religious, connotation. Okay, what is the answer to this question? It refers to immovable property. Section 336 deals with this. So what is the answer? Go ahead. What is the answer? I think we have dealt with this question before also. Be quick. Okay. So Neetu says D, and I think answer is D. Very good, Neetu. Let us now talk about another question. What is this is with reference to distance. Tell me which section it will be and what is the answer. Okay. Gayatri and Neetu say C, but which section it deals with? Distance under the General Clauses Act. The answer is C. But you people did not tell me which section. Distance is dealt with under which section of the General Causes Act? Yes. Write short notes on proviso. Explanation with reference to interpretation of statutes and deeds and document. So section 11 talks about distance. Write short notes on proviso. So proviso is basically a exception again. So the normal function of a proviso is to accept something out of the enactment or to qualify something stated in the enactment, right? And explanation is basically explanation or is a detail about a particular section. It is added to, explain something. Now, this is a question which is very interesting. It says mandatory provision from directory provision. How do you decide and what are the factors which you consider in differentiating between directory or mandatory? So if you will see, practically speaking, the distinction between provision which is mandatory or directory has to be strictly observed. So may and shall is utilized for mandatory and directory provisions. And we have seen that in certain situations, the directory provisions, even if it is shall, we can read it as may, and even if it is may, we have to as shall. But what are the factors which will decide this is nature of the thing empowered to be done, the object for which it is done, and the person for whose benefit the power is to be exercised. So these are the points which are considered while interpreting the mandatory and directory provisions. Okay. So this is the question. Can you give the advice that which dates has to be included? This we have seen just now. So you will see section 9 of the General Clauses Act talks about it, and both the days are exclusive in this particular situation as well. We have seen this particular problem already. Okay. This is again a question, and this question relates to pro rata. So can you solve this? It's a 4-marker question. Can you solve this? I think we have almost toward the end of the presentation. Yes. Solve this question. Yeah. Okay. Let me see. We have got some responses. Company liable to pay 50 rupees. This is what you are saying. Liable to on remaining 50 liters of chemical, which amounts to 5 rupees, not 50 rupees. Okay. So this is thus when a statute fixes a rate per unit, it is on the basis of proportionality, as you have seen, section 12 of the General Clauses Act. Well, what is the answer for this? This is dealing with authorities, right? So tell me which section and what is the point with it. Tell me at least the section which will be applicable. And then we can think about the answer. Yes. Have you got any responses? Yes, come on, students. Quickly answer it. What is the section which will be applicable in this situation of the General Clauses Act? Okay, I think you people are searching. It is section 17 and 18, right? So it talks about the, successor. Basically, it says that irrespective of the fact, if a office, government office has given an order, that will continue irrespective of the fact that this officer who gave that order is no more in office. So whosoever is successor is bound by the result given or answer given in that. I hope this is making sense to you. Okay. Now this is the question, and this talks about the holiday, intervening holiday. This we have already seen section 10. It talks about section 10. So whenever there is a holiday which comes on the last day of the limitation, you move on to the next day, next working day. That is section 10 of the General Clauses Act. Then we have this particular question where the question is about explaining the term government, right? So the definition of government is there in the General Clauses Act, and as per section 323, government would include state government. And in this situation, state government is very much there. So when Income Tax Act provide that gratuity has to be paid by the government to its employee, is fully exempt from tax. It includes even the gratuity paid by the state governments. Now, this is a situation where an urban land ceiling enabled owners to apply for exemption from land ceiling limits. And Raj filed an exemption application in 2022. And the competent authority issued an order granting him that exemption. In 2024, the act was repealed and new law with stricter restriction is enacted. Now, here the state government issues a notice saying that all previously granted exemptions are now stand repealed. So Raj has now challenged the notice, arguing that he had already acquired a vested right under the old act. Do you think his right will sustain? Raj's right, will it be sustained? No. Gayatri says no. Why? It will sustain, right? So under section 6C, repeal does not affect the rights, privileges, obligation, liabilities already accrued, right? So it cannot be subsequently deleted by the government because there will be also a legitimate expectation. Okay, so there is a situation. Uh, sorry. This is with reference to section 6, that is repeal of laws. So under Prevention of Food Adulteration Act, criminal complaint was filed against Meera. In 2023, the act was repealed and Food Safety Act came into force. The trial court closes the case, stating that since the old act has been repealed, the case cannot proceed. Prosecution challenges the order. Do you think the prosecution challenge will stand? Yes. Do you think the prosecution challenge will stand or it will not stand? So here the case will continue, right? So repeal will not affect the previous violations. Similarly, under the Entertainment Tax Act, non-payment of Entertainment Tax Act attracted a penalty of 1 lakh rupees. Arun failed to do that, pay that amount. The act was repealed later. So will his penalty be imposed now or not? Will his penalty will be imposed or not? Yes. Okay. What do you think? No. Uh, right. So section 6, again, D clearly states that repeal does not affect the penalty, right? So section 6 talks about effect of repeal. And under 6, these are the points which we have discussed. This we have already discussed about confusion about financial year and calendar year. So we will skip it. This also we have discussed before. This is again, we have discussed this before. So that's it. This is what was from my side today on interaction. Now, floor is open if you have any specific questions. Otherwise, we have dealt with all the aspects. Any specific questions, I will be happy to answer. Daksh, I think I covered your question on beneficial construction. Any other point which you people want to make or you have to ask a question? Yes, Gayatri, PPT will be uploaded. I will upload the PPT just now. Yeah. Questions? Any other questions? Any other point you want to make? Okay. So in case you don't have any questions, I wish you a good luck for your examinations. I think with you people, I have this last session today, and all the best. This is what I would say. Prepare well, and practice makes you perfect. That is what I can say. And also read the previous year question paper as well as examiner comment. That is going to help you, and prepare your notes. That is the best thing which you can do, and will be helpful to you in your examinations. All the best. IT team, now we can close the session. Yes, yes. Thank you. Thank you. Have a nice day. Bye.